Hi, everyone, and welcome. I'm Cliff Kirsch, and I'd like to welcome you to the Eversheds Sutherland Webcast, Planning for a Patchwork of Best Interest Standards. I'm joined today by my colleagues Eric Arnold, Michael Koffler, Susan Krozik, Carol McLarnon, and Holly Smith. Before we begin, a couple of quick housekeeping notes. If you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Also, if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. And also, if you'd like to request a copy of the slide deck, we're very, very happy to make one available. Just contact any one of us, and we'll get you a copy of the deck. And again, thanks for joining us. We have a lot to cover. Today's webcast will focus on the steps investment advisors and broker-dealers should take as they begin to plan for a patchwork of best interest standards. Like I said, and you'll see on the next slide, slide 3, that we do have, in fact, a lot to cover. We want to get you up to date on where we are with the SEC's proposed standards for broker-dealers and investment advisors. Then there's been a lot of developments on the state insurance side, and we want to cover New York Insurance Regulation 187 and how it's influencing the broker-dealer sale of annuities, as well as developments at the NAIC. And then we also want to turn to state securities development and then look at what's next with the DOL. So a lot to go, but again, that's the whole theme of this hour, a patchwork of best interest standards. So let's start with the SEC, and we start with slide 5. And just to set the stage, back in April, in a 4-to-1 vote, the SEC proposed a comprehensive set of reforms governing the duties and standards of conduct applicable to both broker-dealers and also advisors who provide retail investment advice. And in total, the proposed rules would require that broker-dealers and advisors summarize their relationship to retail investors, establish a broker-dealer best interest standard of conduct, restrict the use of the term advisor or advisor by broker-dealers, and also require investment advisors to adhere to certain conduct as fiduciaries. And the way that the reform package does this is in 3 separate parts. Number one, so you hear what's been talked about, reg best interest. So that's the first part, a broker-dealer standard of conduct, regulation best interest, which would require that broker-dealers, among other things, disclose conflicts, but also mitigate conflicts. And we'll sort of talk about that in a few minutes. The other thing that it would do is introduce new disclosures and titling requirements for broker-dealers, advisors, and dual registrants, the form CRS, relationship disclosure. And with respect to advisors, the SEC proposed a commission interpretation regarding standards of conduct for advisors and a request for comment on enhancing advisor regulation. Michael is going to talk a bit about the advisor interp, but let's just, before I turn it over to Michael to do that, where we are is a 90-day comment period on the package closed on August 7th. So the comment period closed, and then let me turn it to Michael to talk a little bit about the advisor interpretation.
Thanks. Thanks, Cliff. The SEC said it was reaffirming and clarifying the fiduciary duty an advisor owes to its clients, and in the release, the proposed interpretive release really does that. Most of what's in the release has appeared over the past 30 years in various other releases, no action letters, etc. The release talks about the duty of care that advisors owed, including to act in the best interest of the client, best execution obligation to monitor the advice over the course of the relationship. There's not much new there. It reiterated guidance issued in 1994 that best interest is to be evaluated in the context of the overall portfolio, not in particular purchases or sales. Cost is only one of many factors to take into consideration. The obligation to act in the best interest of the client applies to all advice the advisor provides, including but not limited to advice about the investment strategy or engaging a sub-advisor or what type of account to utilize. There's a little discussion about the obligation to provide advice and monitor over the course of the relationship. That can be amended with agreement of the client. And then there's a discussion of best execution, which it just reiterates guidance that was previously provided. The one thing that did get attention in the proposed interpretive release was the increased focus by the Commission on the specificity of the disclosure. There's a sentence in there, which is really the sentence that's gotten more attention than anything else, that says disclosure of a conflict alone is not always sufficient to satisfy the advisor's duty of loyalty, and Section 206 of the Advisors Act. And there's a discussion how the disclosure has to be clear and detailed enough for the client to make a reasonably informed decision. You have to provide sufficiently specific facts, and the release talks about if the facts and circumstances indicate that the client didn't understand the import or nature of the conflict, or the situation is so complex that the material facts could not be fully and fairly disclosed, then disclosure would not suffice. And in that case, the advisor would have to eliminate the conflict or adequately mitigate the conflict so that it could be readily disclosed. So that's really what that last piece is what most people are focused on with respect to the interpretation. The other part of the interpretation was the Commission kind of threw out some trial balloons that were not officially proposed on licensing, continuing education, providing account statements, and financial responsibility in the form of a net capital rule, a fidelity bond, or an annual audit requirement that has not been very well received by the advisor community. So that's the proposed interpretive release in a nutshell.
So that would be, so regulation best interest is proposed rulemaking.
Right.
This is an interpretation, which is sort of a unique way for the SEC to speak. Because, again, it's not a new rule, and supposedly it's not creating new obligations.
Right. The Commission said it was reaffirming and clarifying. Some people would take some issue with that with respect to the last part that I mentioned about the specificity of the disclosure and the fact that disclosure is not always sufficient to cure a conflict. There is some question out there whether the Commission is saying something new, or at least saying it differently than it has in the past.
Great. On the the slide we're on, we talk about what's going on now. We said the comment period closed in August, and the SEC is actively reviewing comments. And while they're actively reviewing comments, they continue to meet with industry groups, investor groups, having investor roundtables. So the debate is continuing while they're going through the formal review of reviewing comments. And there's three major buckets of comments, and a lot of this has been reported. One is by consumer groups, one is by broker-dealers, and one is by advisors. And I think it's fair to say, when all is said and done, it's very hard to come up with a scenario where all of these comments will be satisfied at the end of the day. And I think the SEC is sort of approaching it with that understanding. That and on the next slide we'll start going through some of these comments just to see how different they are. So the consumer groups, and it's really focused on regulation best interest, because again, regulation best interest stops short of saying what? That it's a fiduciary duty. But at the same time, it does, through looking to embrace and enhance suitability, looks to make the broker-dealers' recommendations much more robust. But the consumer groups say it just doesn't go far enough, and the broker-dealer duty should parallel the advisor fiduciary duty. And there's an over-reliance on disclosure. So again, that's one aspect, and the focus of the consumer groups have been with respect to the broker-dealer regulation best interest. A little less focus on the advisor interp and that. On the next slide, we get to the broker-dealer community, and what the broker-dealer community saying is, general support for regulation best interest, and there's an acknowledgement by the broker-dealer community that it does enhance and make more robust suitability, and it requires identification of conflicts of interest, and also those conflicts of interest which create financial incentives have to be mitigated, which is a new concept that's introduced by Regulation Best Interest. Again, conflicts of interest which create financial incentives have to be mitigated, and the broker-dealer community is saying, we need some more guidance here about what is mitigation. Are you saying that it has to be lessened? Is existing supervisory procedures enough? So again, we get it. We get what you're saying, SEC, but we need a little bit more fine-tuning here.
And then there's also a question of when do you have a conflict of interest that doesn't result in a financial incentive? This distinction between financial incentives and other conflicts that don't give rise to that, it has really triggered a lot of comments and questions as to the distinction that the Commission is making.
Right. And there's also a little bit of concern. We talked about the Form CRS, the requirement to disclose the differences between the relationship between advisory relationships and broker-dealer accounts. The broker-dealer community is saying we're somewhat concerned about duplicative disclosure. Will it be understandable and the like? And that also needs some fine-tuning. And then we have the advisor comments, and they're just basically saying you need to extend to broker-dealers the fiduciary principles. So again, it's very hard to see where the SEC ends up with something that's going to satisfy everything. And as Michael was talking about in terms of the fiduciary duty interpretation, some of the other rulemakings that were, I think you used the word floated, Michael, the investment advisor comments really take issue with them.
Right.
So on the last side, we get to where are we now? And we have 5 commissioners, but one will be leaving soon, Commissioner Stein. And, we need 3 votes, so that's what the next few months is going to be looking, for Chairman Clayton, is what his, end game is. As I said, there's been a lot of debate still going on. The debate, continues to be informed by meetings with the SEC in terms of, again, investor groups, industry groups. There's been SEC investor roundtables where the SEC is going out to investor groups and basically saying, what type of disclosures would be effective. There's an investment advisory committee that's pushing for a stronger regulation best interest. That's a voluntary committee. It's not official SEC action, but again, they're urging a stronger regulation best interest. So again, the debate continues. And at the same time, in terms of timing, the SEC has said we're looking to the September time period to have a final rule on the books. And it really seems, as you speak to the staff, it's a commitment that they're all actively working on.
Yeah, I mean, the 2 events that happened most recently, the advisory committee, Cliff, you mentioned, really saying we disagree with the approach taken by the Commission. We think there ought to be a stronger standard for all financial professionals, which is interesting. And then the RAND study, maybe people will in the future refer to this as RAND 2, came out and is being read by at least a good part of the industry, saying, you see, this is proving that based on the investor testing that's occurred, investors don't understand the difference. They are confused by Form CRS. It's not effective, and so the Commission needs to go back to the drawing board. So it'll be interesting to see how the Commission responds to both the advisory committee and the information in the RAND study going forward. Yep,
and so that's the first part of the patchwork, the SEC, and so a lot going on there. And then, if it's okay, Susan, I was going to turn it over to you to talk on this, begin the discussion on the state insurance end of things.
Sure. Thanks very much, Cliff, and hello, everyone. So I'm going to start the state insurance discussion by talking about New York Regulation 187. Regulation 187 is New York's annuity suitability regulation. Like most states, for some time, New York has had a regulation imposing suitability and supervision requirements on the sale and replacement of annuities in New York. This regulation was amended in August of this year. 4 key things to know about the amended regulation. First, the amended regulation will impose a best interest standard rather than a suitability standard on insurance producers when making recommendations. Second, the amended reg will apply to life insurance recommendations as well as annuity recommendations. New York is the first state to do this. And this regulation will apply to variable annuities and variable life insurance and will apply to broker-dealers that are selling insurance products. Third, the amended reg will apply not only to purchase and replacement recommendations, but also to recommendations to convert, modify, or exercise a contractual provision in an existing contract. And last, the rules differ depending on whether or not sales compensation is received in connection with the recommendation. If sales compensation is received, referred to as a sales transaction in the amended reg, the full best interest requirements apply to the recommendation. If no sales compensation is received, referred to as an in-force transaction, a best interest light standard will apply to the recommendation. The amended reg will be phased in. For annuities, the amended reg will take effect on August 1, 2019, the 1-year anniversary of the adoption of the amendment. For life insurance, the amended reg will take effect 6 months later on February 1, 2020. Next. So what does this amended reg mean for producers when it takes effect? For producers, producers will be subject to a best interest standard for their insurance recommendations. Under this standard, producer recommendations must be based on an evaluation of the relevant suitability information for the consumer and must reflect the care, skill, prudence, and diligence that a prudent person acting in a like capacity and familiar with such matters would use under the circumstances then prevailing. In addition, only the interests of the consumer can be considered. Just want to pause on that for a minute. It definitely picks up on some of the phrases and concepts in the best interest standard in the BIC exemption that DOL adopted, and also in the SEC's regulation best interest. It differs, though, in that it effectively disallows any consideration of the producer's own interest. In Regulation BI, it recognizes that a broker has an interest and just requires the broker not to put his own interest ahead of the customer's. But that's not all there is to the best interest requirement in the case of a sales transaction. The transaction must be suitable, and the amended regulation has a new definition of suitable. And the producer must have a reasonable basis for believing 3 things. First, that the consumer is informed about the product being recommended, particularly product features, and the potential consequences of the transaction, both favorable and unfavorable, that the consumer would benefit from certain features of the product, and that the product as a whole is suitable for the consumer based on the consumer's suitability information. In addition to meeting the best interest standard, the producer must also collect suitability information, and in this regard, the amended reg has expanded the list of information that needs to be collected. The producer must also disclose to the consumer all relevant suitability considerations and product information, both favorable and unfavorable, that provide the basis for the recommendation. This can be provided in a reasonable summary format and likely needs to be provided in writing. The producer must document the basis for the recommendation. And lastly, the producer must have a reasonable basis to believe that the consumer has the financial ability to pay for the product. This is similar to a requirement under the FINRA suitability rule. Next. Now, if you are an insurer who distributes annuity or life products through producers rather than directly, you will be subject to enhanced and expanded requirements. For starters, in the case of a sales transaction, an insurer cannot accept an application and issue a policy or make other changes unless the insurer has a reasonable basis to believe that the transaction is suitable based on the consumer's suitability information. Of note, this requirement does not apply to an enforced transaction, one that for which there is no sales compensation paid. The amended reg also expands an insurer's supervision system requirements. The system must include procedures for the collection of consumers' suitability information, documentation and disclosure of the basis for recommendations, review of complaints received by the insurer, review of recommendations made to monitor producers' compliance with the requirements of the amended reg, and must also have audit procedures built into it. The amended reg also requires insurers to make sure that producers are trained to make recommendations in accordance with the amended reg, raising the question whether this means that insurers must provide training on compliance with best interest requirements. One other point to note is that insurers will probably want to revisit the forms that they currently provide to producers and will likely need to develop additional disclosures. Next. To wrap up, just want to offer a few observations about the regulation. First, I referred earlier to best interest light requirements for enforced transactions, those for which no sales compensation is paid. Most of the discrete components of the best interest requirement and related requirements for producers don't apply to these transactions, and as I mentioned, insurers don't have to supervise these transactions. So that is intended to provide some relief from the best interest requirement, but still leaves requirements for producers to consider. The amended reg includes a couple provisions explicitly addressing fee-based annuities, effectively requiring disclosure by producers and insurers regarding any differences in features between the fee-based and commission-based versions of the policy. The amended reg will require producers who have an affiliate arrangement with an insurer to provide affiliation disclosure. Both the fee-based annuity and affiliate disclosures must be submitted to the Insurance Department of New York for approval. The amended reg prohibits producers from using financial advisor or financial planner type designations unless the producer is properly licensed or certified for those services and actually provides those services. This is in many respects similar to the SEC proposal. The amended reg also requires insurers to adopt procedures to prevent financial exploitation and abuse. But the final observation, and I think the aspect of the amended reg likely to get the most attention during implementation, concerns producer compensation. Recall that the best interest requirement requires a producer to consider only the interests of the consumer, implying that the producer must remain blind to his or her own interests. What does this mean for conventional producer compensation arrangements? Well, conventional commission-type compensation is explicitly permitted under the amended reg, so long as the amount of the compensation or receipt of an incentive does not influence the recommendation. Supervision system provisions for insurers also reiterate that differential compensation, where compensation differs from one product to another, and incentives are permitted, but here's the kicker. Only so long as the compensation and incentive practices, when taken as a whole, are designed to avoid recommendations by producers that are not in the best interest of consumers. These provisions are reminiscent of the BIC exemption provisions regarding differential compensation, and they are likely to present the greatest compliance challenge as insurers contemplate how they can demonstrate that the compensation they set for producers is designed to avoid producer recommendations that are not in the best interest of consumers. So with that, I want to turn it over to Eric, who is going to talk about what the NAIC is considering in this arena.
Thanks, Susan. So we just got done talking about a particular state insurance law that's on the books, and to add additional complexity to this patchwork as we're talking about it, we now have an organization that puts out model laws that is looking at effectively doing something similar to what New York has already done with Reg 187. So obviously the patchwork is very complicated and there's lots of hoops to jump through. But what I wanted to do today is just sort of lay out some of the background and activity that's going on at the NAIC with respect to their model annuity suitability regulation, and then sort of look at the status of where it is right now, and a little bit look at it in comparison to what Susan just described for Reg 187, and then talk about sort of what the next steps might be. So the first two slides I'm going to talk through are really just timeline and background. So in 2017, the NAIC convened its annuity suitability working group with a charge to look at and consider revisions to its existing model regulation, Reg 275, the Suitability Annuity Transactions Model Regulation. It's not completely crystal clear what led to the NAIC's decision to convene the working group. Certainly, I think the DOL rule and the reaction to the DOL rule across other non-DOL related sort of regulatory agencies was part of it. But in any event, they decided to open up and take a look at their existing model regulation. The working group has about 20 members on it, and it's chaired by Director Cameron from Idaho and Commissioner Oman from Iowa. I think it's worth noting that New York is on the working group and is playing a very vocal role with respect to the development of the NAIC model reg. They aren't winning all the arguments, but you know what they did at one point during this timeline was just suggest that the NAIC adopt their Reg 187 instead of sort of work through this process. So it's an interesting sort of dynamic of leadership in the working group trying to work through and come up with some potential revisions where states might, you know, have sort of fundamentally different ideas as to what's appropriate or needed. The working group sort of started this off right before Thanksgiving last year, and what they did, they issued a what they called a chair's draft. So they didn't put out the current suitability model reg for comment. What they had done was members of the working group had gone through and marked up the existing suitability reg with what they thought were appropriate or good revisions, and they put that out for comment. They solicited comments and received an awful lot of comment letters at the end of January 2018. And what was interesting is sort of the next step that we saw from the working group was a retreat from the approach of working off of the chair's draft. So they moved away from a document they had spent some time in the summer and fall of 2017 preparing, and just basically said, we're going to start over. And what they did at that point was they reached out and they said, what we want, we've changed our mind. We don't want comments on the chair's draft. What we want is comments on just the model reg. So tell us what you want with the existing model reg and where we should go with that. Next slide. And as they asked for comments on that at the end of April 2018. So I think they gave folks about 30 days to provide comments on that. And sort of right in the middle of that comment period, the SEC came out with Reg BI. So I think there was some thought as to whether or not the announcement and the Reg BI proposal coming out was going to stall the efforts, and that the working group was basically going to say, no, we'll sit on the sideline here and wait until we see sort of where the SEC goes with this, before we move forward. But in somewhat short order, they decided that was definitely not what they wanted to do. What they did then was they took these comments at the end of April, and what they've been doing since the end of April through a series of meetings, including two in-person roll-up-your-sleeves sort of drafting sessions open to the public. One set that occurred at the end of May in Kansas City, 2-day drafting session, and then another session that occurred in October in Chicago. And what happened at these drafting sessions is basically the working group and interested parties just sort of rolled up their sleeves, gave their comments, and worked through each of the provisions of the model reg to try to come up with sort of a new form of the model reg. And I did indicate on the slide here, there's a link in the slide that will take you to the working group's website where all these materials will be. So you can take a look at all of that. So after, multiple meetings, 4 days worth of drafting sessions, sort of where are we? And where we are is a couple days after that Chicago meeting, the NAIC working group sent out an updated model reg that sort of served as a placeholder for where the working group thought all the discussions were at this point. And I would note, too, that the current draft is, there's an aspect of this that's very fluid in that there were a number of topics during these sort of drafting sessions where the chair or vice chair of the working group basically said, well, I think we need to address that, but let's just put a pin in that. We're not actually going to address that now. Let's move forward. So the draft as is out there now, it's unclear how close that is going to be to what the sort of the final draft looks like. But on this slide, what I've tried to do is just highlight some of the primary issues and where they currently rest. So the current draft includes what is sometimes referred to as a suitability plus or a best interest equivalency standard. So what does that mean? Well, it means that they definitely aren't using the term best interest in the reg itself, but a lot of the current concepts are pretty similar to the concepts that we've seen elsewhere. So right now, what they are describing as the standard of conduct is that a producer, when making a recommendation of annuity, shall act in the interests of the consumer at the time the recommendation is made without placing the producer's or insurer's interest ahead of the consumer's interest. So obviously a standard doesn't use the term best interest, but uses some of the language, at least, in terms of whose interest comes first. We've seen in other regulatory regimes, and clearly does not go as far as DFS Rule 187 in terms of what they're setting as the bar. The other piece of this I think is a little bit interesting is that they do adopt a requirement that indicates that the producer will comply with that standard if they act with reasonable diligence, care, skill, and prudence and make suitable recommendations and make all the required disclosures. So they put in this reasonable diligence, care, skill, and prudence, which is sort of a new concept, at least under the insurance laws, in terms of what the standards are that a producer needs to comply with. Then in terms of the other content, the current draft obviously ups the game in terms of disclosure. It requires that producers would describe the scope and terms of the relationship that they have with their clients, so sort of a Form CRS type requirement. It's not, this is something we've seen across a number of different regulatory regimes. Requires producers to disclose whether they have any limits on the types of products or the companies for whom they're offering products. It requires compensation disclosure, and it requires disclosure of material conflicts of interest. So, again, all pretty sort of familiar concepts, I think, in terms of what we've seen over the last 2 or 3 years with standard of conduct developments. A couple of things I'd mention in comparison to New York Rule 187. First of all, this rule definitely doesn't apply to life insurance. New York, at several of the meetings, suggested that it should. The chair and vice chair basically said that both the name of the group and their charges made it impermissible for them to make this reg applicable to life insurance. New York has suggested that they are going to go back to one of the parent committees and request that the charge be opened up to include life insurance. The other piece of this is that's a little bit murky right now, is the applicability of the current draft to post-issuance transactions. So Susan spelled out sort of the regime under Reg 187 for post-issuance transactions. And right now there's been mostly just discussion on this. There's not a lot of language that's included in the current draft that sort of tells us what they think the obligations are with respect to a transaction that occurs after the annuity has already been issued. What there has been so far is discussion amongst some of the working group members that suggests that they think it at least ought to be read to cover post-issuance recommendations for dump-ins of additional cash into the annuity contract. So that's kind of a sort of a huge lurking issue in terms of the applicability of that rule on a go-forward basis. I should say the applicability of that draft of the rule. Next slide. So in terms of next steps, the Annuity Suitability Working Group is actually meeting right now in San Francisco. They had a 9 a.m. meeting this morning, which is right now. The NAIC fall meetings are going on in San Francisco. This meeting's only an hour long, so it's not going to be likely taking too much in terms of like drafting comments, and it's unclear precisely what's going to come out of that meeting. The working group will have an opportunity tomorrow to report up to its parent committee, the Life Insurance and Annuities A Committee. There's a meeting tomorrow where they will be reporting up to them on the progress of their committee. Unclear exactly what they're going to be doing at this point, and I think the path forward could go in a lot of different directions. Throughout the course of this working group, the chair and vice chair have talked about sort of wanting to be in the game and wanting to not be caught flat-footed and wanting to have like a potential sort of working draft of revisions to the standard of conduct applicable to insurance producers. So they've obviously made a lot of progress on that. But as I said, it's sort of unclear what they're going to do with this. It seems pretty unlikely that there's going to be votes sort of approving the language in each of the working group and the A committee. One thing that I've heard floated is this idea that maybe what the working group will do is try to get sort of a conceptual approval from its parent committee and have the parent committee maybe approve a report of the working group, but not actually approve the draft of the model reg itself. So we'll have to just sort of keep an eye on that. But I think, more than likely what we're going to see is continued work on this from that working group well into 2019. And with that, I will turn it over to Holly to talk about some additional state developments.
Hey, Eric and Holly, before we start, I just want to, for housekeeping purposes, for those folks who are interested in getting CLE credit for today's webcast, you'll need a confirmation code, and the confirmation code is patchwork. So again, for those who want CLE credit, the confirmation code is patchwork. So please use the code for the sign-in sheet available for download from your viewing console. Now we can go to the additional development.
Sorry, Cliff.
Good afternoon, everyone. This is Holly Smith. I'm going to pick up where Susan and Eric left off. As you know, they were talking about state insurance law developments. I'm going to turn and talk about state securities law developments. You all probably feel beleaguered that you've been through so much already at the federal level with DOL and with the SEC's proposals, but we cannot lose sight of the state's ability to regulate investment advisor and broker-dealer and their salesperson's conduct through the adoption of legislation or rules that come at it from a securities as opposed to an insurance standpoint. If you go back really more than 20 years now and you try to trace through the ability of the states to regulate both SEC-registered investment advisors as well as SEC-registered broker-dealers, you pretty quickly come to the 1996 federal law, the National Securities Improvements Act of 1996, where there's definitely line drawing between state authority and the authority of the SEC to regulate broker-dealers and investment advisors. And we've all been living with NISMIA for 22 years now. I think it's fair to say that NISMIA has a lot of elasticity to it, and that is what the states rely on. Because what NISMIA basically said was the SEC in many areas has preeminence and can't regulate to a really fine degree things that are within the province of the state, but a state has no, as far as I know, no limits on its exercise of anti-fraud authority. So if a state wants to investigate an SEC investment advisor using its anti-fraud authority, it can do that. The same thing with broker-dealers. So using that authority for the past 20 years or so, the states have done things like NASA has proposed, they proposed shortly after NISMIA was adopted, a model law for unethical business practices for investment advisors and investment advisor reps, and also SEC-registered investment advisors. And I don't know how many of you have had occasion to look at that model law. It's been adopted in many forms by the various states, but it's a good place to look to as a reminder of the way in which states regulate SEC-covered investment advisors and ensure that they are disclosing to clients material conflicts of interest and doing a host of other things that a state would consider as being violating state fiduciary law. Now, turning slightly to some other interesting things here that I just want to mention, NASA submitted a comment letter to the SEC in reaction to the publication of Reg BI. And I would say if you're interested in the state areas, the NASA letter is a good thing to look at because in it they make explicit that they would like the SEC to say in writing in the adoption of any new rules that the new rules are not intended to preempt any state laws or regulations. If you look at the NASA letter, it's very interesting. It says it's well settled that federal and state securities laws coexist and that past and present Congresses intended to maintain only limited preemption of state laws in this field. And then it goes on to hint at the possibility of litigation and says, to the extent this issue ever is litigated, it would be useful to future triers of fact that the Commission, referring to the SEC, speak to this issue, even if merely in a footnote. So we are full bore on record with, I think, what you consider, can consider the position of NASA as an organization and therefore of many states too. So let's go on to slide 23. As I was saying before, certain states already impose fiduciary obligations. Well, I want to go beyond saying certain. I think they probably all impose fiduciary obligations, either through their unethical business practices, rules, and regulations, or through court decisions. And again, if you go back to the SEC proposing release for Reg BI, you can actually see, if you start around page 202, you see the SEC giving a nod to state authority, where the SEC says that when a broker-dealer exercises investment discretion, then it becomes, at least under state law, an investment advisor and is subject to state investment advisor regulation. That is, those 5 pages starting on 202 and going to 207, they are picked up in that NASA comment letter and commented on favorably. So let's turn quickly to the handful of states that are already acting in this area, and so we need to pay particular attention to them. Still on slide 23, Nevada and Connecticut. So those are both examples of states where their state legislatures went after these issues and have adopted legislation that, in both cases, for both of those states, became effective in July 2017. Nevada took the position that it would expand, well, I guess the basic way to say it is it expanded the definition of who a financial planner is. Previously, a financial planner had excluded broker-dealers and investment advisors, and what the Nevada law now says is that a financial planner is a person who, for compensation, among other activities, advises others as to the investment of money, and that the financial planner has the duty of a fiduciary toward a client. Previously, that definition had been in Nevada law, but there had been exclusions for broker-dealers and investment advisors and their sales representatives. So we see this shift in Nevada. You also see the shift in Connecticut, which again enacted a public law that says a financial planner means a person offering individualized financial planning or investment advice to a consumer for compensation where such activity is not otherwise regulated by state or federal law. And in Connecticut, just using that as an example, a financial planner will be required to disclose to a consumer upon request whether or not such financial planner has a fiduciary duty to such consumer for each recommendation such financial planner makes to such consumer. So those are already in place, although we do not have regulations. Turning to the next slide on 24, there are several other states that are, for better or for worse, either had introduced legislation that has now did not make it through the 2018 legislative session, but of course could be reintroduced. Among those states, New York, New Jersey, well, let me pause 1 second here. The states are taking different approaches. Some are using legislative process to get at these issues, and some are using rulemaking. So that is a distinction that we need to make because, as one commentator has pointed out, if a state decides to go the rulemaking route as opposed to the legislative route, that could be an easier path because trying to get legislation through a two-house system could be viewed as more complicated than a state securities division who believe it already has certain authority trying to engage in rulemaking. But if you just look at the states that are either trying a legislative or rulemaking fix, you would count among them New York, New Jersey, Connecticut, Maryland, and also, I apologize, this isn't on the slide, but Illinois. Illinois is another one. So when you look at these states, there are different models they're following, either disclosure-based or an explicit fiduciary, but I would just tell you that from my read of everything that's been proposed, I would not say that what the states are doing can easily be put into buckets. So although for purposes of this slide, we tried to give you examples using New York and Maryland of different styles, I would just say that really, if you're interested in these subjects, you should be looking at the underlying rulemaking or the legislation, because the nuances that are in these acts and rules are very important, and it's not easily characterized. I will move quickly to New Jersey because I think, maybe with the exception of Illinois, New Jersey is the most recent state that is, taking action here. Their initiative is called a pre-proposal, and it is rulemaking, not legislation. And it's interesting in the remarks that have been made by the, I think it's the governor, or it might be the bureau chief for the New Jersey Bureau of Securities, but it's in the public record that the state believes that investors remain without adequate protection from broker-dealers. So that's a pretty far-reaching statement. I realize, as does everyone, why they're saying that, but that's what I mean about the nuances at the state level. In New Jersey, the proposals are right now the subject of hearings. There was a hearing on November 2nd. There's going to be another hearing on November 19th. Testimony is being taken, so I assume there will be a public record. Comments are due on the New Jersey proposal on December 14th. So, moving really quickly, because I want to give Carol time to cover all the five-part test and everything. My prognostication, if that's the right word, I don't see the states particularly backing off. You saw a little bit of a back off by Maryland. They had introduced a bill and then they backed off, maybe in deference to the SEC. But on the whole, the states that are out there right now, Nevada, Connecticut, they already have legislation. New Jersey, I really don't expect the states to back off. So I think this is an area we need to continue to watch. Carol?
Sure. Thank you, Holly. The DOL rule, as we all know, was vacated a little over 6 months ago, but ERISA is still, unfortunately, part of the patchwork, and we're uncertain how it will all play out in the end. I'm going to start backwards with developments because there was some excitement last month when on the semi-annual regulatory agenda of the DOL, there was an entry for a new fiduciary rule. It's not as kind of shocking as it may seem. It was already on the regulatory agenda as a long-term item, and it was switched over to the current category. And along with being called current, it gave a projected date of September 2019, which coincidentally or not has to do with the same time as the SEC guidance is supposed to be final. We're hoping by this that this indicates some sort of coordination with the SEC. We've heard the SEC at least speaking about actively meeting and consulting with the DOL, although the DOL has been very silent as to what this fiduciary rule might be. We haven't been able to get a lot of insight from the new leadership at the DOL. There's very little guidance has come out. What has come out has been not related to the fiduciary rules, but more in the sense of retirement programs, MEPs, MEWAs, which are multi-employer welfare arrangements. This is all guidance that the White House is wanting to have put out on really efficiencies in the retirement system and in benefits in general. So for now, what we're left with is a non-enforcement policy, which says that the DOL will not take action until there is a new rule in effect. If the provider is working in good faith to comply with the impartial conduct standards, which were just overturned by the court system. So if you comply with the rule that's overturned, the DOL is not going to enforce anything against you. But we're not seeing any indication that they're looking to kind of go beyond that. What we're left with is a return to the old 5-part test, which is on the next slide. We'll quickly go over. Really, to point out on this slide, the key differences between the investment advice fiduciary definition that was overturned and the old and now returned to 5-part test is that the 5-part test requires a regular basis. Investment advice has to be provided on a regular basis pursuant to a mutual agreement, arrangement, or understanding that the advice will serve as a primary basis. So this takes the kind of the becoming a fiduciary just because you've mentioned a investment or a security, takes the sales piece out of it, and we're going back to where we're really looking at more of a trusted advisor. There are other ways to become a fiduciary under ERISA if you have discretionary authority or exercise discretionary control over plan assets. You also will be a fiduciary. And just by the way, this definition of fiduciary also applies to the prohibited transaction provisions of the Internal Revenue Code, which governs IRAs. So we do have a concept of a fiduciary as a disqualified person for prohibited transaction purposes, although there's no duties that go along with it other than with the ERISA plans, which will bring us to our next slide, where I'll talk quickly about what the ERISA best interest fiduciary standard of care is. This is something that is actually a statutory definition. Therefore, the fiduciary rule and its vacature have nothing to do with this standard of care. It does differ slightly from the best interest standard that was articulated in the BIC exemption. There were a lot of comments on, why are you setting this new standard when we already have a statutory standard, but we're back to just the statutory standard. And it looks to me, from what I've been listening to, it kind of goes somewhere in between the New York Reg 187 and Reg BI as to its what the standard of care is. But if you look at the second bullet point, it's the care, skill, and diligence of a prudent person. And in ERISA, it's also understood that it's a prudent expert. So if you're giving investment advice, it has to be prudent from a professional investment advisor's perspective. Solely in the interest of plan participants and beneficiaries. This is, again, written into ERISA. It's been interpreted through federal common law. There's nothing specific as to, does it go, do you have to put the standard ahead of the customer, because this is a broader kind of ERISA definition, not specific to the investment world. And the other two are more on the plan level duties. We still have prohibited transactions. They're applicable to both IRAs and ERISA, and those are as they were before the fiduciary rule. And it's 1 o'clock, so I will turn it back to Cliff.
So it's hard to end on this slide of the person in anguish and being overwhelmed, but yeah, we are at the top of the hour. But just a couple of things, just in terms of wrapping up, in terms of steps that folks can take. It really is a fine-tuned legislative tracking and regulatory developments as well, because you see press reports coming out that, going back to Holly's remarks, when New Jersey took their action, talking about New Jersey just passed a fiduciary duty requirement. And again, as Holly said, it's in the pre-planning state. So it's really important to have a very refined legislative and regulatory development tracking. And then we're seeing firms really look to fine-tune their mechanism to identify and inventory and deal with conflicts, mostly with a view to regulation best interest, in terms of what is a conflict, how they're dealing with it, and building on that, disclosures and surveillance with a view to the SEC looking in terms of conflict mitigation as disclosure, surveillance, as possible ways to mitigate. Again, we're running short on time, so I just want to take one question we got, then I'm going to close it out. One question we got is it likely that the SEC may process Regulation BI differently from CRS and the IA interpretation? And the SEC is not suggesting that. If you listen to statements and also speak to the staff, it really seems that regulation best interest, the Form CRS, and the proposed interp are all advancing with a view to action in the August-September timeframe. That being said, I wouldn't be surprised if CRS does get delayed, just because, again, there's a lot of challenges with that in terms of, is that disclosure really effective? Is it workable, given the comments that the SEC received? But for now, the timing of Regulation Best Interest, CRS, and the interp are all slated at the same time. With that, obviously a lot more to come. Thanks everyone for tuning in, and we want to thank you for joining us. As a reminder, if you want to receive CLE credit for the webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And again, the code for that was patchwork. And if you have any questions or if you want a copy of the deck, just reach out to any one of us, and we'd be happy to answer questions or get you a copy of the deck. And again, thanks everyone for joining. We appreciate it.
Thank you. This concludes today's conference. You may disconnect your lines at this time and have a good day.